Sections of a Georgia grand jury report have been released. The jury investigated allegations that President Trump and his allies tried to overturn election results. The panel did not find any evidence of voter fraud. It also recommended perjury charges for some of the 75 witnesses who testified. Katie Cherkasky joins me now. She's a criminal defense attorney and a former federal prosecutor. So let's start with the grand jury recommended releasing its findings, which the court must honor, but the judge can have discretion over what exactly is released and when. What factors do you think were a part of what the judge was weighing to decide to release what little trickled out today?
Well, you're right. The grand jury makes that recommendation, and it is up to the judge. And here, not very much has been released. And the clear speculation is that because there has been recommendations for indictment that are included in there. Now, the special grand jury that made those recommendations can actually issue those indictments, but just the mere fact that those have been recommended and the district attorney will then be considering those caused the judge to keep a lot of that information out from the public because those are still pending cases with criminal defendants that have due process rights.
Can you help us understand the double grand jury situation here? So in a normal instance, when a grand jury sits and then makes its recommendations, what happens? And then in this case, there's a kind of a second beat. And how does that work?
Right, exactly. And this is all based on Georgia law in terms of how they handle these grand juries. So in Georgia, a general grand jury, a regular grand jury that can issue indictments typically sits for a certain term, and they hear all sorts of cases that run the gamut. A special grand jury is not very often used, but it's a function that can be appointed to look at only one specific case, and it may take longer than what a typical grand jury's term is, so that those folks on the special grand jury can focus solely on that investigation. And here, obviously, it was quite extensive with as many witnesses as you mentioned. So that was their function. The only kind of catch to that is that they do not have the authority to issue an indictment. They can only make recommendations. So if this case were to proceed, it would actually have to go before a regular grand jury.
And so, okay, so now the DA, what happens? So the DA would presumably take all of this to a regular grand jury. And what happens there? Do they just read everything and then they make their determination, or do they call in the same witnesses again? Or what's your sense of how long that might take?
Well, I think that's a really good question. And as I mentioned, a special grand jury is a very unique situation and hasn't happened very many times, from my understanding, in the history of even the state of Georgia. So in terms of what the regular grand jury will do, they obviously will have access to all of the same information and the reports that were compiled by the special grand jury. So I don't think they're going to duplicate every effort. But if they wanted to recall in certain folks to clarify certain things or have different interviews of other people that they don't feel were talked to the first time around, I think that they will have pretty wide discretion to add on to the investigation, if you will. But I don't think that they will duplicate every effort just for the sake of doing so. I don't believe that's required, but it's a novel situation. It certainly is.
And there is the old expression that a grand jury will indict a ham sandwich if that's what's wanted. And explain that notion. In other words, you mentioned the grand jury can ask questions and bring people in. But there is that expression which suggests that DAs can get grand juries to do what they want them to do.
Well, sure. And we have to remember that the standard of proof for a grand jury to issue an indictment is typically a probable cause standard, not a beyond a reasonable doubt stating that the case is proven to that level. So the amount of evidence that needs to be presented by the district attorney to garner an indictment is not typically very high. And that's why, district attorneys take cases that they believe they do have proof, not only to surpass a grand jury standard, but to prove beyond a reasonable doubt in court. They take these cases on a discretionary basis, and that's based on the strength of the evidence as they see it. So you're not going to see a lot of cases that don't have some strong form of proof, at least arguably, that are taken to a grand jury, certainly.
And what's your sense of if the DA has to make a determination here? This is different. This is about behavior of the former president while he was in office and a lot of people around him who were serving that president. How would that work into the calculations in terms of bringing indictments and taking something to trial? Because I would assume that would make things more complex and therefore maybe a higher bar to cross.
Well, that's such an interesting topic, and I have talked about this a lot, and I think it's very interesting because, as you mentioned, this is a state that is presumably potentially going after a former president to indict on criminal charges, and that there's a lot of constitutional questions that have never been tested before that would be coming up with a decision like that. Does that mean they can't issue an indictment? No, but there's going to be challenges that are lodged to that along the way. And that being said, from the report that we've seen today, or at least the portions, we know that there's been some recommendations for indictments. We don't know who that pertains to. Obviously, the speculation is it could be Trump himself, but we just don't know that at this point. So if there was to be a decision to pursue this further, I think that there's going to be a very strong battle all the way probably up to the Supreme Court about the ability of a state to prosecute a former president for acts that were committed during the time in office.
Indeed. Katie Cherkasky, thank you so much for being with us.
Thank you.